The right to privacy applied to other activities. The challenge for the court since Griswold has been to determine which activities fall within the scope of the privacy right, and that question has placed the justices at the center of some of the most controversial issues of the day. For example, the first attempt to extend the privacy right, which raised the question of whether the right protected abortion, remains at least as controversial today as it was in 1973 when the court decided the first abortion rights case, Roe v. Wade. In Roe, and the many abortion cases that the court has heard since, the justices have tried to establish whether a woman's right to abortion takes precedence over any interest the state may have in either the woman's health or the fetus's life. Over the time, the court has adopted a compromise position by rejecting the view that the right to abortion is absolute and by attempting to determine when states can regulate or even prohibit access to abortion. In 1992, the court established the undue burden test, which asks whether a state abortion law places a substantial obstacle in the path of a woman seeking an abortion before the fetus attains viability. Although the court used this standard to strike down spousal notification requirements, it has upheld other requirements imposed by some states, including waiting periods, mandatory counseling, and parental consent. The court has also stepped gingerly around other privacy rights, such as the right to choose one's sexual partners and the right to terminate medical treatment or engage in physician-assisted suicide. Both of these rights have been presented to the court as hinging on the much broader right to privacy. With respect to the right to terminate medical treatment, the court has been fairly clear. Various court decisions have confirmed that as long as an individual is competent to terminate treatment, the state may not stop him or her from taking this action, even if stopping treatment will lead to the person's death. The court has been less clear in its rulings when an incompetent person's right is advanced by another individual, such as a spouse, a parent, or a child. In these circumstances, the court has accepted the state's argument that before treatment may be terminated, the state may require that the person seeking to end life show that his or her loved one would have wanted that course of action. When a person's wishes are not clear, loved ones may wage legal battles over whether to discontinue life support. If you're interested in this topic, you should look up the Terri Schiavo case. In cases involving the right to engage in consensual sexual activities with a partner of one's choosing, the Supreme Court has also employed a less than absolute approach. For many years, the court allowed states to criminalize homosexual activity, finding that the right to engage in consensual sexual activity did not extend to same-sex partners. In 2003 case, Lawrence v. Texas, the court changed course by ruling that right to engage in intimate sexual activity was protected as a liberty right, especially when the activity occurred inside one's home and the states could not criminalize this activity. Since that decision, rights activists have worked through the courts and state and federal legislatures to secure the same-sex partners the same rights that heterosexual couples enjoy, including benefits provided by group health insurance and marriage. The right to privacy remains very controversial. Cases brought under the right to privacy tend to link this right with some other civil liberty, such as the protection against unreasonable search and seizure, the right to free speech, or the protection against self-incrimination. In other words, the privacy right, which the justices themselves created, seems to need buttressing by other rights that the Bill of Rights explicitly establishes. The explanation for this development may be the contentiousness of American civic discourse about abortion, aid in dying, and other privacy rights. In short, continuing civic disagreement may have forced the court to fall back on the rights that are well established and much more widely accepted. Public discourse about privacy is constantly evolving as people voluntarily share more and more information about themselves through online networking sites such as Facebook, Twitter, LinkedIn, Google+. Users of such sites and bloggers share stories, photos, and videos of themselves, as well as of others, who may be unaware that they are subject of posting a blog or a video. Civil libertarians worry about the misuse and theft of personal information in a high-tech society where people's financial, employment, consumer, legal, and personal histories are so easily accessible. Government and law enforcement agencies are still deciding how they may use such materials in criminal investigations. It is unclear what a corporation like Google that possesses records of individuals' search terms, emails, phone calls, chats, and social networking posts, and by the way, Google's not alone, Microsoft does the same thing, all conducted on its site, will and can do with such extensive individual identifiable information. This is what we're going to be discussing in class, so please be prepared to do so.